left side or the right side? Well, hold on. I don't like saying left and right because everybody thinks it means Democrat and Republican. I'm going to fall to one side of the north, the east of the west. There we go. We are back on the record now, 28th Circuit Court here in Western County. We're going to continue today's docket call by taking up the case of People of the State of Michigan versus Christian Corrigan. This is case number 25-14029 FH. Appearances begin with the prosecutor, please.
Nate Carnes on behalf of the people.
Good morning, Mayor. Please, Honorable Court, Kareem Johnson, B number 71988, appearing on behalf of Mr. Corrigan.
Thank you. Mr. Corrigan is here seated next to counsel, and Mr. Stephen Saladay is seated next to the prosecutor. He is the probation officer who has prepared today's pre-sentence investigation report. The one thing we need to note here is we had to adjust the sentencing date, so we'll know that that'll be changed on CFJ 145, page 1 at the top right-hand corner from September 8th to September 15th. That will require a change as to the credit, so we'll have to add 7 days there, giving us a total of 220 days of credit. That'll be changed on CFJ 145, page 2, and then of course noted at the top on page 1. I'll take just a quick moment to review my notes. All right, it doesn't look like I saw any corrections. How about you, Mr. Carnes? Any objections, corrections to make to the report?
Yes, Your Honor. OB 12 is scored at 5 points for one felony that was dismissed. That should be 1 point.
Oh, all right, no problem. I assume there's no objection to that, Mr. Johnson?
Correct, Your Honor.
Thank you. All right, so we'll go ahead and change that scoring for offense variable 12 from 5 down to 1 point. That will change the total OV from 15 down to 11. That still keeps it as an OV level 2 and does not impact the minimum guideline range. Anything else, sir?
Nothing further.
Mr. Johnson, how about you, sir?
Yes, Your Honor.
Any other amendments, corrections?
Yes, Your Honor. We'd asked the OB 19, which is currently scored at 10, be scored at 0.
Okay.
Reason stated, and we can see the court can look at conduct outside the sentencing offense.
Yeah.
If the court finds by preponderance of the evidence that the offense occurred. Here, the sentencing offense is possession of methamphetamine. What happened in this case was my client was walking down the street. He had contact with a law enforcement official who was asking to see if he was okay. He told him he was okay. The officer drove off. The officer recognized and ran his name, came back to arrest him for an outstanding warrant. When he got out of the car, my client said, "Wait a minute, what's wrong? I just met with you." And the officer believes that he took a step back and reached for something in his pocket, which was a cell phone that he was pulling out. My client didn't run. He didn't fight. He didn't do anything to evade or delay the arrest in this case. So for the possession of methamphetamine, which was in his book bag, I don't think he engaged in any conduct to try and interfere with the administration of justice of this offense. And we asked the people to dismiss the RNO. They were gracious enough to dismiss the RNO. I can't speak to what their motivations were in dismissing that, whether just to resolve the case or if they believe that there was a sufficiency of evidence issues. I know I've never tried a case in this jurisdiction, but I have tried these, what I call 5-second RNO matters in other jurisdictions, and typically juries tend to side with the defendant, especially with no punch, no kick, no biting, no spitting, any of that occurred. So I've asked the court, and I know the burden of proof here is lower than at a trial, but I still don't believe by the preponderance of the evidence that offense occurred. Yeah.
Thank you. Mr. Carnes, your response.
Your Honor, I'm in a difficult position here because I'm essentially substituting in on this file. As I read the description of the offense reads like an RNO to me. I guess I wouldn't be opposed to taking this up at some point when watching the video, but I'm not sure we have time for that today.
Thank you. One moment as I take a quick. You call them the 5-second RNOs. I call them the, the tensed up RNOs. Because, and I understand the dangers of being a police officer, encountering somebody, especially when you recognize the defendant. By the way, it's very easy to do in Westford County because we're pretty small. There's always a certain number of people that the officers see often. However, I've never been a fan, and I also think prosecutors need to get a little thicker skin with the officers and say, listen, when somebody just tenses and panics, if you touch me, I'm going to panic for a second. I do not think that those tensing RNOs are at all legitimate. Let's say not at all. Sometimes are really not legitimate. The officers get very used to being justified in their actions based upon the danger that they do. So it's kind of a give and take. And I'm not trying to take it away from officers. Prosecutor here, I don't need to know why he dismissed the charge, although it's really easy to figure it out. You get a guilty plea because there's only 2.5 prosecutors and there's 4 or 5 public defenders, plus we got a team of conflict attorneys. So they have to cut deals, and we all know that 95% of cases result in some kind of breach of agreement. So I don't put any stock in that portion. That was the throwaway charge. Plus, by throwing it away, you don't count it as a PRV 7 when it gets counted. It can be counted someplace else. I know when I was a prosecutor, I would always calculate all the scorings of the guidelines and try to figure out how can I give away a charge, but also keep a point on someplace else. So I don't care why they did it or what caused them to do it. The only thing I care about is what I see here in the report. Now, the defendant had 3 active warrants at the time. So the law enforcement, that part was left out, and that's okay. I don't think the defense attorney was hiding anything, but was left out. The officer turned around and after recognizing him and figuring out that he had some warrants. Once he had warrants and he went to go take the defendant into custody, the defendant didn't have a right to go grab it for his phone and quote, calling his people. They say, don't put your hands in your pocket. You don't put your hands in your pocket. Real simple. And you don't get to go, hey, well, I'm going to do something that you don't want me to do. Which is I'm going to call my people. I'm going to be in charge of the situation. And that's kind of the challenge here. Was it an attempt to interfere with justice? And that's really the question. Versus, and Mr. Corrigan, I'm not trying to be rude. Sounds like it. What I'm going to say is going to sound like it. Or was he just being a jerk? And by the way, people can be jerks. That doesn't mean it's an RNO. You can yell at a cop. Hold on, Sonia. No, don't say that. I'm not saying you were, but here's my example. If somebody goes up to an officer comes up to you and the officer says, all right, we're all done. And that person decides to yell, hey, you're a jerk, and calls them a handful of names, not a crime. I've got to try to make a decision here. Was it an attempt to interfere with justice, or was it just being a jerk? So that's how I look at these facts. Well, were you trying to get away from it? Yeah. Dude, you can't do this. Come on. Flailing arms a little bit. What the officer said. He took a step back while removing both hands from winter gloves. Well, that can make an officer feel concerned, right? You can't operate maybe a knife or a firearm with winter gloves on your hands generally. So I'm starting to look now and see, all right, trying to see it from the eyes of the officer. He took a step back What I don't know is how many, it just says you took a step. I don't know what that means. You took a step, you made a fast reaching motion with your right hand arms toward your back right pocket. All right, now that starts to give the officer some concern. So it's elevating it just a little bit, or maybe, I don't want to, maybe the word elevate isn't right, but it's putting a couple pebbles of sand on that scale. So, and of course, the officer mentions here potential concealed contraband or a weapon maybe. One moment. So when you were trying to get to your phone initially, I don't know if that, I don't think that portion was an R&O. So now I start to look here at your actions and the officer's actions. I think were both reasonably understandable up until this point, maybe. It says Corrigan repeatedly stated he was trying to get to his phone. All out, the officer was giving you verbal orders, don't reach for anything. So if at the time the officer was telling you, don't reach for anything, and you continued to reach for a phone or reach for something in your back pocket, even though you claimed it was a phone, the officer didn't have to believe that it was a phone. So in response, the officer continued to, quote, apply pressure and keep him pinned on the patrol vehicle, end quote. Then the officer or trooper orders you to turn around, according to the statements here, and place your hands behind your back. Then the officer said he attempted to turn you away from him and back towards the vehicle. But at that time, allegedly here, it says Corrigan pushed back against him, not allowing the trooper to turn him. Then the trooper advised that if he did not, meaning Mr. Corrigan, turn around, he would take him to the ground. Corrigan still did not turn around, and Corrigan was placed on the ground. So to me, it appears that there is a preponderance of the evidence to conclude that from one perspective, maybe Mr. Corrigan was, they said they found the phone. Maybe he wasn't reaching for a phone. But the thing here is in the presence of that moment, what is going on in the eyes of the officer? It's a little bit more than somebody goes to put cuffs on you. If you're a guy and you don't tense, I'd be surprised. Right? Most men, by the way, like to walk around with their shoulders up and looking tough. So anyways. But in the eyes of the officer who's trying to do his job, and he's given some instruction. I'm not a fan of this theory we have out there in the world today that, well, fight or resist an officer. Yes, you can resist an officer if their actions are unlawful. His actions were unlawful. There was a warrant. 3 of them actually. So the officer was not unlawful by stopping, was not acting unlawful by taking him into custody. And even though Mr. Corrigan may in the back of his mind thought, hey, I get to do this, or I get to call, quote, my people, the answer would be, no, you don't have the right to call your people. You have the responsibility to do what the officer tells you. So I'm going to say it's quite, it's a little bit thin. Let me take a quick look here at the statute. I'm sorry, at the court rule, not the court rule, the statute for variable. 1 second. We're talking OB 19. OB 19 allows a score of 10 points when the offender otherwise interfered with Don't know if he actually interfered with, but did he attempt to interfere with the administration of justice directly or indirectly? Oh, sorry, that's the next part. Sorry, skip that. Did he attempt to interfere with the administration of justice? The court hereby makes a finding pursuant to the facts I discussed that the defendant by preponderance of the evidence was, albeit at a very limited scale. I don't think it's high, but it just says to interfere. And the court finds that there was an attempt to interfere, therefore the court will deny the challenge to OB 19. All right, Mr. Johnson, anything further?
No, Your Honor.
All right, any other corrections, objections to any other point? I want to make sure you didn't think I was just talking about OBs.
No, Your Honor.
All right, allocution then, sir.
On the date of the offense, my client is walking in the county. He's not committing any crime. He's not intoxicated or drunk in public. As the court has indicated from reading the officer's description of offense, the initial contact between law enforcement and my client was just law enforcement trying to make sure that he was okay. The interaction was cordial. Both parties went their separate ways. The officer recognized him to be speaking to, ran him in lead, saw he had a warrant, and came back to effectuate the arrest. Again, my client wasn't high, other than having a warrant, wasn't committing any crime. The court has made its ruling on what has happened next, but I want to just state for the court that after the client was taken into custody, as indicated in the motion that was withdrawn with the plea, the officer let him make the phone call that he wanted to make to begin with. And another individual came and picked up his belongings that weren't going to the county jail, and he was taken without incident. My client has been in the county jail now for 210 days. He has completed 5 hours of voluntary substance use treatment while in the Western County Jail. I have reached out and contacted Salvation Army Rehabilitation Life and Work Skill Program in Detroit. It was a program that my client was interested in. I have spoken to them about the intake process. If my client was sentenced to probation, they would be willing to admit him into the program. There's a 1-800 number that he would have to call. It is an inpatient program, and he would have to stay inpatient and be in inpatient treatment for the duration of the program. And if the court saw fit, and I believe the court would have to deviate from the guidelines now based upon the scoring. The court saw fit to hold any further incarceration in abeyance based on completion of the program as a condition of probation. I think my client can and would comply with the program. In terms of, I do have a petition here for the program. In terms of supporting documentation, with this particular program, there is no application or anything for me to bring to the court. There's a 1-800 number that my client will call. He would either be admitted into the program or not, and they would arrange pickup for him, yeah. And I'd ask the court to allow us to petition for the court to participate in that program. I do believe that the outstanding issue here is really two. Not taking care of the simple warrants that he had and being in possession of narcotics. So he does have a narcotics problem. But again, he was not out on this particular day committing any underlying offense. He wasn't stealing or robbing or drug habit. He wasn't high out in the community, posing a danger or a nuisance to other individuals that were out in the community now.
Thank you very much, Mr. Jonathan. Mr. Carnes.
Thank you, Your Honor. I really don't disagree with Mr. Johnson's description of this event. It does appear the defendant was walking, not causing any problems, but he had 3 misdemeanor warrants for his arrest. And then even while reviewing this file for sentencing, I noticed this seems to be a recurring issue: absconding on bond, on probation, on parole. And committing new crimes while on bond, probation, or parole. For those reasons, at this time, I don't think Mr. Corrigan is a good candidate for this kind of release to treatment, which obviously I've been in favor of in certain files. If he completes this sentence, including the supervision, spectacularly, hopefully that he's done. Hopefully he gets treatment while on parole. But I do think the recommendation here is reasonable in light of defendant's history, especially when I focus on his conduct on probation and parole. Thank you.
Thank you. Mr. Porter, I'm sorry, and by the way, in case you were going to say it, I don't know if you're going to, Mr. Johnson, I'll note that he wasn't on probation or parole at this time, where this picked up.
Okay.
Yep, but were you going to say something else? Looked like you wanted to, I thought you made a gesture.
Well, I didn't know what this court, this is my first sentence. I don't know if the court
It's okay.
gives me a rebuttal.
If I generally don't, but if you, that's why I interrupted. I saw you do that. And the one thing I thought that you might comment on was that regarding on this particular case, you were Mr. Corrigan on probation, bond, or parole. So I don't want you to think that that's going to filter it. All right. Do you have anything further, Mr. Johnson?
No, we'd ask, I understand the government's concerns. We'd ask the court to consider doing it in the inverse, sentencing him to a county jail sentence.
Yeah.
And after a determined amount of time, then allow him to petition to the Salvation Army Center.
Thank you. All right, Mr. Corrigan, it's your time to say something if you choose to do so, or something you wish to say, sir. All right, go ahead.
Okay, so
It's all right. You may remain seated. You can stand, whatever makes you the most comfortable. I know that it's not always comfortable to stand and
yeah, so I am actually already accepted to this program. I am also accepted to the Grace Center of Hope in Pontiac. They're just waiting on this court date. And I understand that what I had was illegal, and you know, I do agree with the fact that I wasn't really out doing anything in particular to draw attention to myself and stuff. But I did go on a furlough. I came back clean, no issues. I was actually back to the jail early. I would just say that prior to this offense, 4 days prior to this offense, I sent a text message to my dad and asked him if I could move back into his house and get clean because I wanted to focus on my life. And he lived in Manton and I was stuck in Cadillac and I couldn't find a ride home for 4 days. And then I caught this offense. And then while I was in here, my dad passed away on April 5th. So I didn't even, you know what I mean? I missed that opportunity. And being incarcerated, I actually watched someone pass away in the jail. So I've already been through quite a lot in my jail stay. And I've been working on getting my medications right and trying to control my anger and my bipolar and stuff like that. So I would just ask that you do consider the treatment because I've already been to prison. I've already been on parole. I've been off parole for over a year now before I caught this offense. And it just seems like incarceration isn't the right way to do things. And I feel like I need like more than even a clinical rehab can offer me. I feel like the Salvation Army or the Grace Center of Hope would be a really good thing for me because they have 40-hour-a-week work program where you have to, that's how you get to stay there. You work 40 hours a week. And the Salvation Army program is 6 months at 40 hours a week. That's close to the longest time I've ever held a job in my life. You know, and I've been a trustee for 5.5 months in the county jail. I'm sure you've been seeing me around every time.
I know, I recognize what you're wearing. Yep.
And I wanted to stop. I wanted to be done. I was already tired of it, wasting my days sitting there hiding away from my warrants. I was tired of it and I wanted to stop. And I missed my opportunity. I missed to be there for my dad. I missed a lot of stuff and it's been life changing. So I just ask that you consider all that.
Well, I gotta start talking, so, all right. All right, so let me walk through this. I'm gonna hit several factors. And I'll tell you that I'm still sitting on the fence, so just wait till I get done. As I talk, maybe I'll convince myself one left side or the right side. Well, hold on, I don't like saying left and right because everybody thinks it means Democrat and Republican. I'm gonna fall to one side of the north, the east or the west. There we go. I'm not really sure. Mr. Corrigan, you present to me a confused position. You've been in jail now for 220 days in this file. You're 30 years of age, and you have been in constant trouble since the age of 15. Started a couple years before that. You had a couple year gap, and then starting in 2010, the wheels went off. Regardless of what I sentence you to here in a few moments, on CFJ 145, page 1, is a list of substances with which you have struggled. Beginning in 2007, when you were 13, 12 or 13. And then by the time you were 18, not even that, 15, you start adding a whole bunch of substances, prescription meds, marijuana, opiates, meth. Right now, unfortunately, on this page that I'm holding up for you, it just has one date, a general start date. We don't know exactly the precise date, but there are no end dates. Very first thing, no matter what I do for a sentence, you in your mind have to put end dates there for each one of those. That includes marijuana and alcohol, even though they may be legal. Till you fix you, gotta put some end dates there, or you're just gonna keep coming back to see me. I don't mind you coming back to see me if it's not in an orange or red jumpsuit. You can come back and say hi, but stop coming in jumpsuits. All right. So I'm really concerned, but the positive message here for me is, in your own mind, Christian, put some end dates there. And make sure those end dates are today or before today. All right, next. I appreciate, now I understand why Mr. Johnson, then you even commented on the fact that you weren't out causing trouble. You were out for a walk. But that negates the fact that had you been doing something else, you might have gotten in even deeper trouble. And there was nothing, the officers did nothing wrong as far as recognizing you, because of course that's why you were hiding out. That was the phrase you used, hiding from your warrant. Recognize you, pulled, took you under custody, and then found them out. It doesn't matter. You had warrants and you had meth. I do appreciate you weren't doing more stupid stuff, but you still had meth. Now, you have been to an inpatient program on an addiction treatment services. I think that's up in Traverse City. Was that at Tokoski Hall? Yeah. I think that was a couple of years ago. I don't remember how long ago it was. It was like 2021 maybe. Anyways. 20, yeah, all right, there we go. All right, well. As I continue, I look at your criminal history. This is probably the one thing you don't want me to talk about, but I have to. Your juvenile history had quite a few entries. Like I said, it began in 2006. That was a B&E. Looks like you were discharged from probation in 2007, and you made it about 3 years until getting picked up again. Now there you were placed into the Muskegon River Youth Home. You went AWOL relatively soon after. You had some other probation violations. I think you actually went AWOL twice, and I'm counting at least 1, 2, 3, 4 probation violations. In fact, while you were on probation there, you picked up entry 3 of 4 as a juvenile, and in that file, it also shows those same violations again. So we know that in 2010, it wasn't a good year for you. I know this one case here was dismissed, number 4 of 4. You picked up your first adult conviction while you were on juvenile probation. And in that file, you had a couple multiple probation violations. You had been on probation for all of 3 months before you picked up number 2 of 21 in 2012. Discount obviously entry 3 of 21 in the criminal history because there was a dismissal. But still within 3 months, you picked up number 4 of 21 while on probation. And we start to see that alcohol here is an issue right now already at that young age. We've got issues with our assault resistant drugs, but also B&Es. Then between 2 and 4, I already counted 4. That's when you committed the MIP while on probation. You made it 4 months before getting picked up again in district court while on probation. That was a drug possession. You actually had going on at about that time a series of 3 different sets of cases involving alcohol, marijuana, and drugs. You're still violating probation. Pick up another one 3 months after number 7 of 21. You picked up number 8 of 21. This one was down in Kentucky. Looks like that case was resolved in May of 2014. You made it 4 months before getting back up here to Michigan and committing another offense, relatively minor in possession, but clearly the substances are an issue. Then you made it about a year between that and 2016 when you picked up 10 of 21. However, you had bond violations. Then you had another year gap. You picked up crime without a license. Not a big charge, but you couldn't make it much more than a year. Then, while you were dealing with 11 of 21, you picked up 12 of 21 in 2018 while on bond. Between that case being resolved and the next case, number 13 of 21, you made it 4 months. Then between that and the next one, you made it 2 days. Yeah, you had been on bond on October 19th of 2018 and 19th, and you got out and you made it 2 days before picking up another series of charges. At the same time, you had another case down in Osceola County, one of your popular offenses, which is B&Es or larcenies. Then you picked up another one while on bond, same time as when possession is met, probation violations. 4 months later, while pending the last warrant, you picked up number 17 of 21. You had probation, you had a probation violation there. And of course, we see now narcotics. Then you made it 6 months onto your probation. You picked up the next case. This was a destruction of property, sounds like out of the jail. There you had a probation violation. Then 19 of 21 occurs while on probation. That's more drug charges. And you had 11 parole violations while you were on supervision. 20 of 21 occurred while on parole, a relatively minor offense, operating while your license was suspended, denied, or revoked. To me, though, I consider those as somebody doing what they want when they think as long as they don't get caught, they'll be okay. And then a year after being off of parole, you pick up this case. So your ability for supervision is quite questionable. You've had issues filing bond, filing probation, filing parole. You've had cases that overlap. You've had short times in between offenses. And basically since the age of 15, you've been constantly in trouble dodging law enforcement, but not doing that good of a job at it. You are, again, 30 years of age, and you have 5 children with 5 different mothers. That's quite concerning because that means you're probably not out there earning money and paying child support. When I look at those drug uses, it's 1 to 2 times a week. quite a mixture. You got opiates, barbiturates, alcohol, cocaine, or alcohol, cannabis, and amphetamines. Don't know what it takes. Sorry that you lost your dad. I have absolutely no doubt that your childhood and the relationships you had with your family have contributed to the position in which you find yourself today. I also generally have found you to be fairly likable, but I'm afraid that that can also play against the court here. Good people struggle with substance use disorder. Even young people who've started off with it in the world with problems and family and home life and controlled substances and alcohol and marijuana, sets a pattern. It impacts their brain development and it continues into them being an adult. So I'm not quite sure about what to do. All right, the sentences of the court will be as follows. The court assesses a $68 state minimum fee, a $130 crime victim right fund fee. Not going to do any court costs, not going to do any fine. I'm going to do a $300 attorney fee. All right, the court sentences the defendant to a prison term of 20 to 120 months with 220 days of credit. That is less than what was recommended, and I will also note that I find it to be proportionate and reasonable under both circumstances for OV-19. For instance, if I were to have granted the modification of OV-19, that would have reduced this in a Class D chart from OV level 2 to OV level 1. Today is an OV level 2. The guideline range is 19 to 38 months for the minimum. However, if I had granted the motion or the challenge to OV-19, it would have been reduced down to a 10 to 23 minimum range, which means my sentence is within both. Therefore, I think that it's even more proportional because I think it fits both theories of the consideration of offense variable 19. All right, Mr. Corrigan, Mr. Johnson's going to bring you 2 copies of one document. You're going to place your initials on one. Doing so neither elects nor waives any rights. It merely acknowledges receipt of this copy of the document. Your other copy. Yeah, yep, come on.
Yes, sir, may I approach?
Yeah, of course. Thank you. Place your initials again does not elect nor waive any rights. It merely acknowledges receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal if there's been a conviction at a trial. However, based upon this plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Excuse me, the court is not going to make the payment of fines and costs contingent for parole. All right, I set them low, but I'm not going to let it hinder you on parole. Now, Christian, here's the reasoning behind it. You don't have to like it, but I'm just going to explain it. Stop it. It's just the best word I can come up with. 30 years of age, 5 kids. Take that loss that you had with your father and realize how important he could have been or was to you and how much more important he could have been had he continued to live. Now imagine how important you can be to these 5 kids. The part that my tendency here is to recognize that I see in you, and I don't think I'm wrong. If I am, then shame on me. I see a good person who just, for some reason, has something in his head that's not working right. I'm not gonna let that empathy that I have or sympathy I have for you allow me to let it perpetuate. I want you to think of 5 kids every day and your role in their life. And if you feel that loss from your dad, which I know you do, don't do anything further that's gonna cause them to lose their dad. You can come out, get into rehab, you can become a peer recovery coach, all those things. I'm hoping you use this time wisely. Did I miss anything, Mr. Saladay? Or any further, Mr. Carnes?
No, Your Honor.
And anything further from you, Mr. Johnson?
No, Your Honor.
And Mr. Johnson, I did make some comments about some of the things about how he didn't, that may have sounded like I was arguing against you. I really thought you did a very nice job today arguing. I really appreciate that. I know you're not from the area. I know you're coming up here to help us out. And I know that you're helping a young man who's one of ours. And so I wasn't trying to argue against you, but I was just kind of responding to them. And again, thank you very much for representing Mr. Corrigan.
Yes, Your Honor. Thank you.
Thank you. Mr. Johnson, you can just turn that into the clerk. Good luck. We're adjourned.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.